Dear students, today we are going to discuss WAKF and its essentials. Whenever a Muslim dedicates his property in such a way that the property and its corpus is tied up or detained, and its produce or income is reserved for pious, religious, or charitable purposes recognized under Muslim law, it is said that a waqf is created. Waqf is very closely related with the belief system of Muslims. Generally, a waqf is created by a Muslim in order to please God. Therefore, the institution of waqf is very closely related with the religious faith of Muslims. Now, let us try to understand the meaning of waqf. The literal meaning of waqf is detention. Detention. In the language of law, waqf means detention of a property so that its produce or income, which is also known as usufruct, may be available for religious or charitable purposes. Now, what happens? What is the meaning of detention? What does it mean? How can one say that a property is detained? When a waqf is created, the property is detained or tied up forever. And thereafter, it becomes non transferable. Now, this is the point which needs to be understood. When the property is detained or tied up forever, it means it has now become non transferable. This is what the meaning of detention is. The property has become non transferable in such a way that it is still generating some income and produce. It will continue to generate some income and produce. And that income and produce will be available for religious and charitable use. When a Muslim creates a waqf, generally his desire is to please God. Now, let us try to understand it further. How it originated, how the institution of waqf came into being. The Muslim law on this subject has got its origin in the traditions of Prophet, peace be upon him. So you will find the instances of waqf in the traditions, that means Sunnah of Prophet, peace be upon him. It is reported that one of the companions, very famous companion, Umar, had a piece of land of which he wanted to make the most pious use. So he approached Prophet, peace be upon him, and sought his advice. The Prophet, peace be upon him, then declared. What did he say? He said, tie up the property and devote the usufruct to human beings. Tie up the property and devote the usufruct to human beings. And it is not to be sold. What is not to be sold? The property. Or made the subject of gift or inheritance. Now, the property can neither be gifted away nor anybody can get that property in inheritance by succession. This is what is the meaning of tying up the property is, or detention of the property is. Now the property can no longer be transferred. No one can sell it, no one can gift it, no one can get that property in inheritance. This is the meaning of detention or tying up. For how many years? For how long? Forever. It can never be transferred. It can never be gifted away. It can never be, I mean, obtained in inheritance. What will happen to the income or usufruct or the produce of that property? Prophet said, devote the usufruct, that means the produce or income, to human beings. For the benefit of human beings, devote the produce or income or usufruct of that property. So Umar followed. Umar constituted a waqf of that piece of land. This waqf continued to exist for several continued to exist for several centuries, and after many centuries, it naturally died away, disappeared. Since then, the practice of creating waqfs has become an important part of religious life and social economy of Muslim society. We witness lakhs of works in created by Muslim society. Now, for making the property non-transferable, I repeat, for making the property non-transferable, the Muslim jurists, especially the Hanafis, ev- evolved the theory of transferring the ownership of the property in favor of God. What does it mean? It means that whenever a Muslim, especially a Hanafi Muslim, creates a waqf, that means he dedicates his property, he actually transfers the property in the implied ownership of God. When the property is transferred in the implied ownership of God, the person who has dedicated is no longer the owner of that property. Who is the owner the property of the property? God. And that is why it is transferred. It is said that it has been transferred in the implied ownership of God. So the ownership of the property in a waqf is vested in God, whereas its benefits or produce, whatever the income is there, benefits are produced, are given regularly for the fulfillment of religious and charitable objects. However, according to Shia law, the ownership of Waqf property is transferred to the beneficiaries. Shia law has a different theory. It says that the ownership of Waqf property is transferred to the beneficiaries. Hanafis consider that the property has been transferred in the implied ownership of God. However, Shia law considers that the property is transferred in the ownership of beneficiaries. Now let us try to understand some of the definitions which have been given under some of the acts which have been enacted relating to Waqf. There is one act which is called the Musalman Waqf Validating Act. This act defines Waqf in the following words. It says that Waqf means the permanent dedication by a person professing Muslim faith of any property. What does it mean? It means it is a permanent dedication by a person professing Muslim faith of any property for any purpose recognized by Muslim law as religious, pious, or charitable. There is another act which is known as Waqf Act 1954. This act also defines in similar words. It says that Waqf means the permanent dedication by a person professing the Islam of any movable or immovable property. In the earlier definition, the words were of any property. In this definition, It has been explained as of any movable or immovable property for any purpose recognized by Muslim law as religious, pious, or charitable. Now, from this definition and from other things also, the characteristic features of Waqf can be understood. What are the characteristic features of Waqf? The first characteristic feature of Waqf is perpetuity. Perpetuity. Perpetuity is an essential element of Waqf, very essential. Once the property is given for Waqf, it remains for Waqf forever. Forever, I repeat. What does it mean? Perpetuity means when a Waqf is created, it cannot be created for a fixed period of time. Once it is created, it has been created forever. सदैव के लिए, हमेशा के लिए, जब तक वो प्रॉपर्टी अस्तित्व में रहेगी, एग्जिस्टेंस में रहेगी. दिस इज द मीनिंग ऑफ परपीचुटी. वक्फ कैन नॉट बी फॉर अ specified period of time. In a case, Musammad Piran versus Hafiz Muhammad, it was held by Allahabad High Court that waqf of a house built on a land leased for a fixed term was invalid. For a fixed term, it is invalid. It cannot be created for a fixed period of time. Once it is created for all time to come. Now, the second characteristic feature of Waqf is inalienability. In simple words, it means non-transferability. Since Waqf property belongs to God, according to Hanafi jurisprudence, no human being can alienate it for himself or any other person. It cannot be sold or given away to anybody. That is the meaning of non-transferability. So, it is when a waqf is created, it is for all time to come, and the property becomes non-transferable. Now, the third characteristic feature is irrevocability. Irrevocability, that means it cannot be revoked. Once it is created, the person who has created is also known as WAKF. The dedicator is known as WAKF. The WAKF or his descendants, his legal heirs, do not have the right to revoke it. In the creation of Waqf, it is implied that since the ownership of property is presumed to vest immediately in God, the settlement is irrevocable. In India, a Waqf, once declared and complete, cannot be revoked. The law as applied in India under Muslim law on this point is that it cannot be revoked. The Waqif cannot get his property back in his name or in any other's name. Now, the fourth characteristic feature is absoluteness. What does it mean? It means that the settlement of the property in Waqf is unconditional and absolute. The dedication is absolute and unconditional. A conditional or contingent Waqf is void. If anybody wants to create any conditional Waqf or contingent Waqf, such a Waqf is void. And now, fifth feature is religious or charitable use of usufruct. I have repeatedly said that the produce or income of the Waqf is reserved for religious or charitable use. One point must not be forgotten, that under Muslim law, it is very important to note that if a Waqf is created for the benefit of descendants by the Waqif, if the Waqif creates a Waqf for his family members and his descendants, such a Waqf is known as private Waqf or family Waqf, or in other words, it is called Waqf alal Aulad. For the benefit of family members and descendants, if anybody creates a Waqf, such a Waqf is valid under Muslim law. And it is considered under Muslim law that if anyone wants to create or creates actually a Waqf for his own family members and descendants, this is also a religious and pious work. And therefore, this object is recognized under Muslim law. Now, what are the essentials of a valid waqf? When somebody creates a waqf, what are the essentials of a valid waqf? There are 5 essentials. Number one, there must be a permanent dedication. The dedication cannot be temporary. Number two, the founder of the waqf, who is also known as WAKF, must be a competent person. So the one who creates the waqf must be a competent person. The waqf cannot be created by a person who is incompetent. Now, the third is the subject matter must be transferable property. Property is at the center of waqf whenever a waqf is created. So, what kind of property? It should be a transferable property. Number fourth is the object of the waqf must be religious, pious, or charitable under Muslim law. And the last one is the formalities required to constitute the waqf must be duly completed. The formalities must be completed. Now let us try to understand one by one. The first essential says that there must be a permanent dedication of any property. What does it mean? There are 3 aspects. It means that there must be, number one, there must be a dedication. Number two, the dedication must be permanent. Number three, the dedication can be of any property. There is no prescribed form of dedication. It can be written or oral. So when somebody dedicates his or her property, such a dedication may be written or oral, but it must be clear to convey the intention of the dedication. It must not be ambiguous. According to Abu Yusuf, whose opinion on this point is followed in India, mere declaration of dedication is sufficient for completion of waqf. Abu Yusuf is a jurist, Muslim jurist, whose opinion on this point is followed in India. He says that mere declaration of dedication is sufficient for completion of waqf. Neither delivery of possession nor appointment of mutawalli. Mutawalli is the person who has the responsibility to manage the waqf is necessary. So dedication must be permanent. Dedication cannot be made for a fixed period of time. For example, 10 years or lifetime of any person. Even lifetime of any person is a fixed period. So it cannot be a temporary dedication. It must always be a permanent dedication. That means that is why the one of the features of waqf is perpetuity, for all time to come, forever. And the subject matter of the waqf can be any property. It may be a movable property or immovable property, but that property must be owned by the WAKF. That means the dedicator. Now, the second essential condition is that the founder of the waqf must be a competent person. What does it mean? There are 2 aspects of being competent. Number one is that the founder must have the capacity. Number two, the founder must have the right to constitute the waqf. So what does it mean? Let us try to understand one by one. Capacity to make waqf, the first condition, is that every Muslim who is of sound mind and has attained the age of majority has the capacity to constitute a waqf. Number one, generally he is a Muslim, but he must be of sound mind. He must be a major. If these qualities one has, then that person has the capacity to create a waqf, to constitute a waqf. That person must also have the right to create waqf. What does this signify? This signifies that the subject matter of the waqf, that is the property, must be in the ownership of the dedicator, the waqif. It must be owned by the waqif. If the waqif owns that property, then he may dedicate it, he may create waqf. One cannot dedicate someone else's property. It goes without saying. It is so obvious. Now, one very fine point which must be understood. That is it necessary that the dedicator must be a Muslim? Is it necessary that the person who is creating a waqf must be a Muslim? This question arises because in both Musliman Waqf Validating Act 1913 and Waqf Act 1954, the definition says so, that the dedicator is a Muslim, a person professing Musliman faith or Islam dedicates the property. So the impression emerges as if only a Muslim can create a waqf. There is no denying that generally, a waqf is created by Muslims. There is no denying this fact. No one can deny this fact. Most of the waqfs which have been created by Muslims. So there is no doubt about it. But a very pertinent question arises, and that is, does a non-Muslim have no right to create a waqf? The answer has been given by Amir Ali. Amir Ali says that even a non-Muslim can create a waqf if, and this is the fine point which must be understood, if the object of the waqf is not opposed to the creed of the dedicator. To the creed of the dedicator. It is not opposed, the object of the waqf. The purpose for which the waqf has been created is not opposed to the creed of the dedicator. That is, the object of the waqf should be such that it is recognized both under Muslim law as well as the dedicator's faith. The object should be such which is recognized under both Muslim law and the dedicator's faith. If such a situation exists, then even a non-Muslim can create a waqf. But generally, waqfs are created by Muslims. Now, the subject matter must be a transferable property. The subject matter of waqf can be any property, whether movable or immovable. There were differences earlier where some of the jurists said that only immovable property could be dedicated by way of waqf. Now it is recognized, and as law applies in India, both movable and immovable property can be dedicated for waqf. Now the fourth requirement says that for any purpose recognized under Muslim law as religious, pious, or charitable. The purpose should be such that it is religious, charitable, or pious, recognized under Muslim law. Now, how, on what basis any purpose is said to be religious, pious, or charitable? The answer is, this is to be decided on the basis of the principles of Islam. Who will decide? The court will decide. The court will decide on the basis of the principles of Islam. And once it is found that the purpose is recognized under Muslim law, then it is a valid purpose. It is significant to note, again, I'm repeating, it is significant to note that under Muslim law, making provisions for the maintenance of one's own children and descendant is regarded as a pious work. It is regarded as a pious work. Here I have given a list of the things which have been held to be valid in decided cases by our court of law, by our courts. These purposes have been recognized as religious, charitable, and pious. For these purposes and such other purposes, the waqf can be created and they are recognized under Muslim law. The last essential requirement of a valid waqf is that the formalities required to constitute waqf must be duly completed. Muslim law does not prescribe any specific formality for creating a waqf. A waqf is usually created in the following ways, in the following three ways. How waqf is created? There is no prescribed formality for creating waqf. In the beginning, I had said that the dedication may be written, may be oral, both. It is possible. So there are three ways in which it has been seen and the law recognizes that in these three ways, Waqf can be created. What are these three ways? By an act of a living person. A living person may dedicate the property. By his act, Waqf comes into existence. Now, the second is by will. Through will, a Waqf can be created by the dedicator. There is another third way, by usage. What is it? It means when a property has been in use for charitable or religious purpose for a very long time. There is no proof that the dedicator actually dedicated it. There is no will in which the dedicator said so. But for a very long time, a property is being used for charitable or religious purpose. It is deemed to belong to Waqf. Now, in this manner also, Waqf is created. No declaration is necessary, and Waqf is inferred in this situation. In this situation, where a place has been used for Waqf for a very long time, such a property is inferred as Waqf. It is said that the property is a Waqf, and by usage for a very long time, it has not been objected by anybody. Neither the owner has objected, nor his descendants have objected, and the property continues to be used as Waqf. So, if it is used for a very long time, by usage, that property becomes a Waqf. So, this is what I want to tell you today about Waqf and its essential requirements. I hope you have understood it, and if you go through my lecture and slides twice or thrice, you will be able to comprehend it. Thank you very much.